State.
The state has no more witnesses. The state rests.
Okay. At this point, I need you to put your notebooks on your chairs, and you need to give me a couple minutes to address some matters, then we'll be back with you. Okay, thank you, everybody.
Move to dismiss at the completion of the state's case, Your Honor, on all charges, but specifically I want to raise a multiplicity challenge to the newly added charge of hiding a corpse. We started with the mutilation of a corpse charge. The state amended the information, of course, before we began. Raising a multiplicity challenge. I think that these are essentially in this context with the same victim, the same body, essentially the same crime or the same elements, if you will, and I think one should be struck.
The hiding and the mutilating are two different acts, and so they don't have the same elements. They're two different crimes and require two different criminal acts. Certainly they can overlap, as I think the evidence showed they did here, but those are two different crimes. So that would be my response to that.
Just a moment. Okay, so relative to multiplicity. Multiplicity exists when a defendant is charged in more than one count for a single offense. And the double jeopardy provisions of the state and federal constitutions protect a defendant from being punished twice for the same offense. Under Wisconsin law, we employ a two-pronged test to determine whether charges against a defendant are multiplicitous in nature. First, whether the charged offenses are identical in law and fact. And second, if the offenses are not identical in law and fact, whether the legislature intended the multiple offenses to be brought as a single count. In this particular case, the defense is arguing that the two counts relative to hiding or burying a corpse is charged in count 4, and count 2, mutilation of a corpse, are multiplicitous. So looking at the elements, which is one of the standards that has to be reviewed, I need to look at whether or not the offenses are identical in law and fact. As to the mutilating a corpse, there are two elements. It's first that the defendant dismembered a corpse, and second that the defendant dismembered the corpse with the intent to conceal a crime. Looking at count 4, the two elements of hiding or burying a corpse are one, that the defendant hid a corpse. Second, that the defendant hid a corpse with the intent to conceal the crime. There clearly are different elements in law relative to the two offenses. As to the difference in fact, there are different acts that would be different actions that would be involved in dismembering a corpse versus hiding a corpse. So I think in this particular matter, the two offenses are not identical in law or fact. I next need to look at whether the legislature intended that multiple offenses be brought as a single count. And in so doing, you look at whether or not the legislature, in the drafting and creation of the statutes, set out different elements under Blockberger that amounts to the fact that their intent was to allow for different crimes to be prosecuted under the same subsection. At this point in time, looking at the facts and looking at the law and doing an elements only test, I am going to find that the two offenses moving forward are not multiplicitous and that they are allowable. So I'm denying the defense motion relative to multiplicity. Defense.
Yes, I made a motion for directed verdict on all counts, Your Honor.
Do you wish to make any further argument?
No.
State.
Not unless you would like an argument.
No. So what I can tell you, Mr. Anderson, is at the close of the state's case in chief, what the court has to do is has to look at the evidence in the light most favorable to the state. So looking at the evidence in the light most favorable to the state, was the evidence adduced, believed, and rationally considered sufficient to prove guilt beyond a reasonable doubt? Or in other words, has the evidence that's been presented during the course of this trial in the light most favorable to the state of Wisconsin, could a reasonable jury find you guilty? Looking at the facts underlying this matter, the evidence that's been presented during the course of this trial, to some extent, would be that on April 1st, you were at the Twisted Fisherman with Sade Robinson, that you arrived at 5:09, that she arrived at 5:20, that you both left the premises at a 6:24, that you then proceeded to Duke's on Water, arriving at 6:35, leaving the establishment at 9:04 p.m., that you proceeded to Anderson's home, 3161 South 39th Street, and arrived approximately 9:20 p.m. What we know is that on April 2nd of 2024, at Warnemont Park, at 2:53 a.m., the Civic arrived. At 4:32, the Civic departed. We know that on that same day, the leg of the victim was found. What we also know is that we watched a number of videos that tracked the progress of the vehicle, the Civic, around different aspects of Milwaukee. The videos at no point showed the driver or whether the driver was the sole occupant in the vehicle, at least not clearly. At 4:44 a.m., there was a white spot at a window and a lighter flashing or a lighter appearance in the driver's seat. Whether the white spot was a white hand or the white shadowing was a white person in the driver's seat, or whether that was a glove, that's going to be left to the weigher of credibility. At 7:30 a.m., we know that the Civic was set on fire behind the abandoned building. We know that the seat was in a position that fit a person who's 6'1". We know that your measurements are that on the time this happened, you were 6'1" and a weight was approximately 180 pounds. We heard the testimony that the value of the Civic was approximately $20,000. And based on the videos that were presented, a reasonable jury could conclude that that was you, that was in an approximate distance from the burning vehicle, that you left the area of the burning vehicle shortly after it appears it was set on fire, that you traversed and entered a bus at 8:07 a.m., that you exited the bus at 8:34 a.m., that you were arrested on April 4th, and during the course of the arrest, you were visibly shaking. On April 4th, 5th, and 16th, search warrants were executed at your home. At Galena Park, on April 5th, there were parts of the victim that were recovered in the form of different pieces of flesh as well as a left foot. There was blanket found, small flesh, bone, and large piece of human leg on the 6th, and there were ball joints with ligaments recovered on the 7th. From the testimony that was adduced during the course of this hearing, I don't think those bloody gloves that were found on April 9th had anything to do with anything. And we know that the torso with the arm were recovered on Marina Road on the 18th. We heard the testimony from the medical examiner that the death was homicide by unspecified means. And we heard the Life 360 and phone information and tracking information, which reflect that the phone of Sade remained at your house until 9:24 p.m., that the phone ultimately thereafter was not stationary, that it went down Capitol to the Mitchell Parkway to Warnemont Park, remained static at Warnemont from 2:40 to 4:33. It was in Warnemont Park, I believe, from 3 to 4:30 a.m. The last communication with the phone was on East Howard when the battery died. We know that Sade was reported missing on April 2nd, that you were the last person in communication or in presence publicly with her, that the videos of your home were poor quality. The testimony by Detective Rachel Smith was noteworthy. She indicated that she spent hundreds of hours viewing this video of your house and watching those hundreds of videos. And she basically saw the arrival at 9:20 p.m. and that the Civic departed on April 2nd at 12:47 a.m. She went through all of the testimony relative to the timing about the gate opening, the outdoor movement and gate not opening, the silhouette exiting the gate the same size as the fence at 11:25, the light going out at 11:27, 11:42 a person goes into the premises, the motion light goes on for human movement with a person the size of the fence at 11:56. At 11:58, we have human movement at the back gate area. At 12:12, we have the gate closing again. 12:42, we have human movement inside the premises. And ultimately at 12:47 and 20 seconds, we have the Civic leaving the house. We also have the fact that on the bus video, you return to your residence at 8:42 a.m. wearing the green hooded sweatshirt and dressed differently. We have the fact that you went to the dugout on the following day for work. Noteworthy, we have the photos that were recovered from your home. It's noteworthy that the photos of Sade reflected her buttocks and her underwear pulled down as if the underwear were pulled down with the pants and that it rolled over the pants, which is pretty much just how they were found in the trunk of the vehicle that was set on fire, that you were found walking away from. We also have the fact that there's a photo of a white hand grabbing her right breast, and the right breast is the breast that was dismembered from her body on the torso that was recovered. We also have the fact that there was the photo of bleach and what not to combine with bleach, which I think a reasonable inference could be that someone on your phone was looking for information relative to how to clean up something or a crime scene. So looking at all of these factors together, it's a circumstantial case, but as we know, according to our jury instructions, circumstantial evidence may be found to be stronger than direct evidence. And at this point in time, I am going to find that a jury acting reasonably could convict you on all charges as posed. So I'm going to deny the defense motion, and what that means is I'm going to allow this matter to proceed to the jury. They have a different balancing than I have. So at this point, my view is, in the light most favorable to the state, do they have the means to convict? A jury at the conclusion of the case, their job is to determine whether or not the state has proven each and every element beyond a reasonable doubt. So I deny the defense motion. Have you spoken to your client, or do you need a moment to speak to him?
No, 1 minute, please. Okay, I've spoken to him.
Okay. Have you spoken with your client relative, well, let me ask you this. Do you intend to present any witnesses other than the defendant?
Defense rests.
Okay. So, Mr. Anderson, have you discussed with your attorney your constitutional right to testify as well as your constitutional right not to testify?
Yes, Your Honor.
And has your attorney answered all your questions?
He has, Your Honor.
And you understand that in a criminal case, you do not need to prove your innocence, but the state must prove your guilt beyond a reasonable doubt. Understood?
Yes.
And you understand that if you choose to testify, you would be subject to cross-examination by these prosecutors.
I understand.
And you understand if you choose not to testify, that cannot be commented on by anyone. That cannot be used against you. Understood?
Yes.
And have you had enough time to discuss this decision to testify or not to testify with your lawyer?
Yes, Your Honor, I have.
Have your attorneys provided you with their professional opinion?
They have.
Has anyone, including your lawyers, made any promises to you or offered you anything to arrive at this decision?
No, Your Honor.
Has anyone, including your lawyers, threatened you or coerced you in any way to arrive at this decision?
No.
Do you believe you're making this decision freely and voluntarily?
Yes.
Do you have any questions for me about this decision?
No.
Do you believe you're doing this with full understanding?
Yes.
Have you used any drugs or alcohol in the past 24 hours?
No.
Are you taking any medication that would affect your understanding of these proceedings today?
No.
After thinking through everything we just talked about just now, is it still your decision not to testify?
That is my decision.
Attorney Cotton, have you discussed with your client his constitutional right as well as his right to testify as well as his constitutional right not to testify?
Yes, just to be clear, it's been a subject of course discussion throughout this case, including the last 2 nights after trial. We've had jail visits to discuss that. Mr. Findling and I have both discussed it with him.
And are you satisfied he understands what his rights entail?
He does.
And have you advised him of your professional opinion?
Yes.
And are you aware of anyone making any threats or promises using any force or coercion towards him in respect to this decision?
No, I'm not aware of any such threats.
Are you so satisfied that he's making his decision freely, voluntarily, knowingly, and with full understanding?
Yes.
I am as well. I, in fact, find that the defendant is waiving his right to testify, and he's doing so freely, voluntarily, knowingly, and with full understanding. let's proceed at this point in time to do a conference relative to jury instructions and verdicts. I've printed off new verdicts for you. Prior to the matter being called, the state indicated they were seeking a lesser included on count 1. I did add in 1018. Is that still the state's position?
It is.
Defense, did you wish to be heard on that?
Yes, give me 1 minute, please.
Okay.
It's a new development. Okay, no, I don't need to be heard on that, Judge. I don't have any, I've discussed it with Mr. Anderson, and I don't have an objection to that.
It's basically what I need to look at is whether or not a jury acting reasonably based on the evidence presented during the course of the trial could come to a reasonable decision on a lesser included. And that's the analysis the court has to make when a party requests a lesser included. In this case, I find it's appropriate, and I will add in the lesser included, so we will use 1018. So my intention relative to the instructions would be 100 opening instruction, 115, 1 defendant, 4 counts. Count 1, 1018, first degree intentional, followed by first degree reckless. Then moving on to 1193, mutilating a corpse. 1408, arson of property other than a building. 1194, hiding or burying a corpse. Then proceeding on to evidence defined, 103. Then 147, improper questions. 148, objections of counsel, evidence received over objection. I don't think I ever struck any testimony. Did I?
I think
It was asked, but then I think you withdrew.
Yeah, I don't recall any testimony being stricken.
Attorney Cotton?
Yeah, there was one comment where a witness had said "they" instead of the civic. That was struck, but
I'll leave it in. It's it's 2 sentences.
yeah.
157, remarks of counsel. State, I'm sure you want 170, circumstantial evidence, and 172, circumstantial evidence, flight, escape, concealment.
Yes.
Then 190, weight of evidence. 195, jurors' knowledge. I put in 200, opinion testimony. I took out the word expert because I think that's inappropriate to have in the title. 141, I assume the defense is requesting.
Yes.
201, opinion of a witness. I put that in relative to Detective Donahue's testimony when he was providing an opinion as to his hearing of what was the audio portion of the video. Any objection to that?
No.
And that's,
201.
no, I know that. There's also the recordings played to a jury 158
So I just,
covers that, which would cover that.
okay, I can put that in if you'd like me to. I think that it doesn't add much to anything, but I'm happy to.
I think
Okay.
it's redundant,
Yeah.
and what the jury needs to be instructed on is covered in 201. Or, yeah, 201.
Do you want 158 or do you want to just stand with 201?
No, I think it's, I was just pointing out it's essentially covered under 201, so that's fine.
Okay, so you're not requesting an additional one.
Right.
Okay, then I did put in opinion testimony. Again, I took out expert and I put in the hypothetical question because there were a couple of hypotheticals posed. I'll remove 327 because the defendant didn't testify. We had one witness with a prior conviction, but was the question ever asked if he had a prior conviction?
No, it wasn't relevant.
I did not ask him.
And I don't think defense did either. So I'm going to take out 325. Is the defense requesting 315?
Yes.
Okay. 315 is in. I wasn't sure how the evidence would come in, whether or not 247 applied or not. And I'm thinking it does not, unless either side wants it.
I don't think it applies.
No.
Okay, it's gone. Then 300, credibility of witnesses, taking out the paragraph that would only have applied had the defendant testified. Burden of proof and presumption of innocence, closing arguments of counsel, closing instructions, then verdict submitted, and you'll see that I modified 484 to meet the lesser included, and that'll match the verdicts that are in your possession at this point. Then 515, unanimous verdict. Any additional instructions, state, or modification, state seeking?
No?
Defense?
No.
Okay, I'm going to print you each a fresh copy. It is 2:53. I think we have plenty of time left in the day.
I'm ready to go.
Awesome. Then I'm going to give you 7 minutes, and then we'll start at 3 o'clock with closing arguments. Do I need to set a time limit?
30 minutes would be fine for each of us, I think we discussed.
I do 45.
I'll give you each 45 minutes as a max to be utilized between initial and rebuttal. Fair?
Yep.
Okay, I'll print you fresh copies, and we'll start in 7 minutes. Okay, we are back on the record. Could all of you pass your notebooks down towards Deputy Benz, please? So when you were last here, the state rested, subject to rebuttal. Does the defense intend to present any case?
No witnesses, Your Honor.
Then at this point in time, I'm deeming the evidence closed. So here's the plan for the afternoon. It is 3:05. I'm going to read to you the instructions, and then we're going to go into clearly proven by the evidence. Consider only the evidence received during this trial and the law that I give to you in coming to your conclusions and your verdict in this case. If any member of this jury has an impression of my opinion as to whether the defendant is guilty or not guilty, you should disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and I am the judge of the law only. Now, the first count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, in Milwaukee County, did cause the death of Sade Robinson, another human being, with the intent to kill that person, contrary to Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The defendant in this case is charged with first-degree intentional homicide, and you must first consider whether the defendant is guilty of that offense. If you're not satisfied that the defendant is guilty of first-degree intentional homicide, you must consider whether the defendant is guilty of first-degree reckless homicide, which is a less serious degree of criminal homicide. Now, the crime referred to as first-degree intentional and first-degree reckless homicide are different types of homicide. Homicide is the taking of the life of another human being. The degree of homicide is defined by the law, depends on the facts and circumstances of each particular case. Both intentional and reckless homicide require that the defendant cause the death of the victim. First-degree intentional homicide requires the state to prove that the defendant acted with the intent to kill. First-degree reckless homicide requires that the defendant acted recklessly under circumstances which showed utter disregard for human life. It is for you to decide of what type of homicide the defendant is guilty, if guilty at all, according to the instructions which define the two offenses. Now, first-degree intentional homicide is defined in 940.01 of our criminal code and is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. One, that the defendant caused the death of Sade Robinson. Cause means that the defendant's act was a substantial factor in producing the death. Two, that the defendant acted with the intent to kill Sade Robinson. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive by itself does not establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you're satisfied beyond a reasonable doubt that the defendant caused the death of Sade Robinson with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you're not so satisfied, you must find the defendant not guilty of first-degree intentional homicide, and you should consider whether the defendant is guilty of first-degree reckless homicide in violation of statutory section 940.02 sub 1, which is a lesser included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree intentional homicide, you should consider whether the defendant is guilty of first-degree reckless homicide. Now, as I already stated, first-degree reckless homicide is defined in 940.02 sub 1 of our criminal code and is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of first-degree reckless homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. One, that the defendant caused the death of Sade Robinson. Cause means the defendant's act was a substantial factor in producing the death. Two, that the defendant caused the death by criminally reckless conduct. Criminally reckless conduct means that the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The third element is that the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all the other facts and circumstances relating to the conduct. Consider also the defendant's conduct after the death, to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time that the death occurred. If you're satisfied beyond a reasonable doubt that the defendant caused the death of Sade Robinson by criminally reckless conduct and the circumstances of the conduct showed utter disregard for human life, you should find the defendant guilty of first-degree reckless homicide. If you're not so satisfied, you must find the defendant not guilty. You are not in any event to find the defendant guilty of more than one of these offenses. Now, the second count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, in Milwaukee County, Wisconsin, did dismember a corpse with the intent to conceal a crime, contrary to Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of this offense charge beyond a reasonable doubt. Section 940.11 sub 1 of our criminal code is violated by one who mutilates, disfigures, or dismembers a corpse with the intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. One, that the defendant dismembered a corpse. Two, that the defendant dismembered a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, statements, if any, and from all of the facts and circumstances in the case bearing upon intent. If you're satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you're not so satisfied, you must find the defendant not guilty. Now, the third count in the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, at 2926 West Lisbon Avenue in the city of Milwaukee, Milwaukee County, Wisconsin, by means of fire, did intentionally damage the property, other than a building, of Sade Robinson valued at $100 or more without that person's consent, contrary to Wisconsin statutes. To this charge, again, the defendant has entered a plea of not guilty, which means the state must prove every element of this offense charge beyond a reasonable doubt. Arson is defined in 943.03 of our criminal code and is committed by one who, by means of fire, intentionally damages any property of another without that person's consent if the property is not a building and has a value of $100 or more. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 5 elements were present. Number 1, that the defendant intentionally damaged a 2020 Honda Civic by means of fire. Damage means injured, charred, defaced, and includes smoke damage. Intentionally means that the defendant must have had the mental purpose to damage the property of another by means of fire, or was aware that his conduct was practically certain to cause the damage to the property. The second element is that the 2020 Honda Civic was the property of another. Property of another means property in which a person other than the defendant has a legal interest, which the defendant has no right to defeat or impair, even though the defendant may also have a legal interest in the property. The third element is that the defendant damaged the property by fire without the owner's consent. The fourth element is the value of the 2020 Honda Civic was $100 or more. And the fifth element is that the defendant knew that the 2020 Honda Civic belonged to another person, and that the other person did not consent to the damage of the property, and that the value of the property was $100 or more. Again, you cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in the case which bear upon intent and knowledge. If you're satisfied beyond a reasonable doubt that all 5 elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The fourth count in the information charges that Maxwell Anderson, on or about Tuesday, April 2nd, 2024, in Milwaukee County, Wisconsin, did hide a corpse with the intent to conceal a crime contrary to Wisconsin statutes. To this charge, again, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Section 940.11 sub 2 of our criminal code is violated by one who hides or buries a corpse with the intent to conceal a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. 1, that the defendant hid a corpse. 2, that the defendant hid a corpse with the intent to conceal a crime. Can't look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in the case bearing upon intent. If you're satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you're not so satisfied, you must find the defendant not guilty. Now, evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who calls a witness. Second, the exhibits the court receives, whether or not they go to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which I've directed you to find. Anything you have seen or heard outside of this courtroom is not evidence. You are to decide this case solely on the evidence offered and received at trial. Disregard entirely any question that I did not allow to be answered. Do not guess at what a witness's answer might have been. If a question itself suggested certain information might be true, ignore the suggestion and do not even consider it as evidence. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusion from the fact that an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, I am not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and of the weight of the evidence. During the trial, I have ordered certain testimony to be stricken. Disregard all stricken testimony. Remarks of the attorneys are not evidence. If a remark suggested certain facts not in evidence, disregard the suggestion. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after an alleged crime was committed. Whether the evidence shows consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. Ordinarily, a witness may only testify about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which an opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. The identification of the defendant is an issue in this case, and you should give it your careful attention. You should consider the reliability of any identification made by a witness, whether made in or out of court. You should consider the credibility of a witness making an identification of the defendant in the same way you consider credibility of any other witness. Identification evidence involves an expression of belief or impression by a witness. Its value depends on the opportunity the witness had to observe the offender at the time of the offense and later to make a reliable identification. Consider a witness's opportunity for observation, how long the observation lasted, how close a witness was, the lighting, the mental state of the witness at the time, the physical ability of the witness to see and hear events, and any other circumstances of the observation. You should also consider the period of time which elapses between a witness's observation and the identification of the defendant, and any intervening events which may have affected or influenced the identification. In evaluating the identification evidence, you are to consider those factors which might affect human perception and memory, and all the influences and circumstances relating to the identification. Then give the evidence the weight you believe it should receive. If you find that the crime alleged was committed, before you may find the defendant guilty, you must be satisfied beyond a reasonable doubt that the defendant is the person who committed the crime. Ordinarily, a witness may testify only about facts. However, in this case, Detective Casey Donahue was allowed to give an opinion as to what he heard on a video-audio recording. In determining the weight you give to this opinion, you should consider the witness's opportunity to observe what happened and the extent to which the opinion is based on that observation. Opinion evidence was received to help you reach a conclusion. However, you are not bound by the opinion of any witness. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it was based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is the believability of the witnesses and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on a witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of the trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or the lack of clearness of the witness's recollection, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any's been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you, and you should do the same thing here. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty, unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs in life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions that I have given to you.